Hi, so I want to go through occupiers' liability in the law of torts. I'm going to split the video into two. So I'm going to do kind of the basics, and then I'm going to look at the 1984 Act. I'm going to look at those two together just because they're the two smaller parts, and then I'll probably do a separate summary about the 1957 Act. So occupiers' liability is a special area of negligence. If you're all right with negligence, then you should be all right with occupiers' liability. And it's just where Parliament has gone out of their way to clarify the rules of the duty of care that occupiers owe to people that go on their property. So it's really just like negligence law. It's just that they've put it in a statute to make it really, really clear and obvious. So this looks at the duty of care that an occupier owes to visitors on their premises. So to start with, in an essay or a problem scenario, you need to talk about the basics. Now the basics mostly have their roots in common law. So it's quite ironic that neither of the Occupiers' Liability Acts actually defined who or what an occupier is. So first things first, you need to define that. So there can be more than one occupier of a premise. We've seen this in Wheat versus E. Lakin. It was decided in the case of Collier versus Anglia Water Authority, decided in Harris versus Birkenhead Corporation. There can be more than one occupier, and essentially an occupier is someone with sufficient control over premises. So for example, if you think of a tenant in a property, the landlord is the occupier because they have control over the property, and so is the tenant because they have control over the property. So how does the claimant decide who to sue? Well, essentially what you have to do is think who was responsible for the thing that injured the claimant. Who was the person who was best placed to do something about the hazard? So for example, if someone is injured by faulty wiring in premises in like a rented house, I would say faulty wiring is down to the owner, the landlord, and therefore they're the person that you would sue. However, if the hazard is something that hasn't been tidied up properly, that's probably more under the tenant's control because the landlord wouldn't bother with tidying up the house. So therefore you would sue the tenant. So there can be more than one. So first thing you would need to do, especially if it's a problem scenario, is state that with some case examples and then decide who are the occupiers and then who would the claimant sue if there's more than one. Now there might just be one, which makes it easy, or there might be more than one. So remember, sue the person who is responsible for the thing that harmed them. Then you need to talk about premises. Now, again, that's quite a wide-ranging term, especially when we look at building in criminal law. Premises is another quite specific term, and you need to think about what the different types are. So remember, an occupier is a person with control. Now, premises, everybody seems to remember in the exam the definition that's under section 138 of the Occupiers' Liability Act 1957. They didn't actually go into detail of what premises are, but they did kind of give some direction. So if you remember, section 138 talks about any fixed or movable structure, which is fine. It's a very, very wide definition. There's probably not a lot that doesn't come within that definition, although we did have an exam question a little while back which involved a swan. Now, yes, a swan can move, but it's not a structure. So that wasn't included. It has to be something like, for example, a garage, a greenhouse, a house, etc. But what the Act doesn't state, because it's actually obvious, but students forget this, is that it also covers any land or, I'm not going to fit this in, any building. So basically, almost anything on your property is your premises. So think about your own homes and relate this back. So what would be classed as your premises, your house, the shed, the greenhouse, the kids' slide in the back garden, the swing set, pretty much everything within your boundaries is going to fall under this. So yes, it's a fixed and movable structure on your land, but also the land and the buildings on themselves. So a person has to be injured on the occupier's premises. And key one that again tends to get overlooked, I really like this when students talk about it in the exam, I think it's really high level. They have to be injured because of the state of the premises. Basically, the premises haven't been maintained very well, that's why you're suing. If it's just that you are on someone's property and, for example, so you're accidentally hit by a football, that is not you being injured because of the state of the premises, and therefore it wouldn't be occupier's liability. There has to be something hazardous that the occupier hasn't dealt with on your land. If, for example, in the case of Tomlinson versus Congleton Borough Council, the claimant dived into a deep body of water and essentially broke their neck. He sued the council that was occupying that lake, and the Supreme Court pointed out, or the House of Lords as they were then, they pointed out that they weren't injured because of the state of the premises. There was nothing wrong with the lake. The lake was just fine. He was injured because of the dodgy dive. So it has to be injured because of the state of those premises. So those three elements remain the same, no matter which area of law you're talking about. So deal with those first. Then you've got to make a crucial decision if it's a scenario question. Who was the person injured? Were they a lawful visitor or not a lawful visitor? Because that's going to really determine which act applies to them, what duty of care is owed to them, and what they can sue for. So if you're a lawful visitor, so what is a lawful visitor? Give some examples. So we have invitees. Now be careful, these are people you actually ask onto your property. Yeah, invite. So, if you invite your friend round for dinner, you've asked them to come round. You hire a builder to come and, redo your kitchen. They're an invitee. You've asked them to come round. Now, licensees are slightly different. Licensees have a temporary permission to do a certain purpose. Your typical example is a customer in a shop. They are allowed into a shop temporarily for a certain purpose to buy things. The idea is once they've done that purpose, they leave. So if you buy a ticket to the cinema, you can't just keep going in and out of every screen because you've bought temporary permission for a certain purpose to watch that film. Now, students often get confused with customers in a shop and talk about them being invitees. Now, unless the shopkeeper has stood on the street and gone, hey, you, come on in, they aren't invitees. Shops don't stand, they don't have staff at the door. Well, they do at the moment, but they don't have staff at the door saying, I grant you permission to enter, coming in. It's just implied. Finally, there are some people who have a statutory right to enter your property, whether you like it or not. And I always think it's quite ironic that you still have a duty to protect these people, even though the reasons that they have a statutory right to enter is because generally you won't let them in otherwise. So again, you want some examples. So we are talking about the police. That's probably the easiest one to remember. Social workers, environmental officers. There was a case where a police officer was making an arrest at someone's house, slipped over a paving stone, broke their ankle, and they sued the homeowner under occupier's liability. So they weren't invited, and in fact, you don't want that person there, but while they are there, you owe them a duty of care. So these groups of people are lawfully on your property and are covered by the original law, the Occupiers Liability Act 1957, and that means if you are able to prove a duty of care, you can sue for personal injury, including death, and any damage to your property. Now, if you don't fall into these categories, there are some other kind of exceptions about rights of way and things like that. But the main category is if you're a trespasser. A trespasser is a person without permission to be on the premises or that part of the premises. So a typical example that we tend to see is maybe someone who starts off lawful but becomes unlawful. So for example, a customer normally, properly, legally goes into a shop. There is a big sign on a door saying staff only. Person goes in anyway. They then become a trespasser because they exceed their purpose and their permission. Now, how do I know which law to apply in that case? What is their status when they're actually hurt? So if that person is injured before they go through the staff only door, they're a lawful visitor and the 57 Act applies. But if that person is hurt once they've gone through the staff only door, they are now a trespasser and they have to claim under the 1984 Act. So this was made by Parliament long after the original law, and it recognised that trespassers should at least be owed what we call sometimes a basic common duty of humanity. So they may be trespassers, they may be burglars, you may not want them there, that's the whole point, but they are people at the end of the day. So we owe them a basic minimum duty to make sure they're not horribly maimed on your property. Now, because of that, they are only entitled to claim for personal injury up to death. They are not entitled to have their stuff protected. They have fewer rights than lawful visitors because they're not supposed to be there. But a common thing I see in the exam is that students will tell me that trespassers have rights. They will explain this person as a trespasser. They will tell me the things that the occupier's done wrong. And then at the end of their scenario answer, they'll tell me they can't sue because they're a trespasser, completely ignoring everything else. Now, people might not like it, you might not agree with it, but if you are a trespasser, you still have some basic rights. So you can sue if you're hurt, but not your stuff. Little exam tip, if someone's stuff is damaged, they probably are a trespasser because it's testing you to see if you remember the distinction. Right, okay, so once you've decided which law applies, let's talk about this 84 Act in more detail. Tends to be the worst of the two. Students don't tend to know it very well. Hopefully you can see it okay. So this duty, this common duty of humanity, is a lot more restrictive. The rules are outlined in section 1, subsection 3. And remember, if you want those higher marks, you do need to be putting in these section numbers. All 3 criteria must be satisfied. Only then will the occupier owe duty of care. First, was the occupier aware that there was a danger on their premises, or they reasonably should be? That stops people denying it. Should they have been aware? If I have a massive hole in the middle of my front garden, I probably should be aware of that, even if I'm saying I wasn't. Next, key mistakes students make in the exam. Was the occupier aware that someone might go within the vicinity of that danger? Now, they don't have to predict that trespassers will go near it. So, but going back to my staff only example earlier, would a shop owner expect trespassers to go through that door? Possibly not, although they've put a sign up. They were aware people might go through. But the staff might go through that door. They're entitled to protection. So are you aware there's a danger? And are you aware people might end up near it and hurting themselves? It's not rocket science. And also it's not particularly unjust. Finally, was it something that you should have reasonably protected against it? We're building a picture here. Did you know there was a danger that people might go near and it would have been easy enough to protect against it? Well, you know what you should have done? Protect against it. If they're hurt, that's then your fault. So the key case that this all sprung from was the case of British Railways Board versus Harrington 1972. That easily applies here. The railway board was aware that there was a hole in the fence that could be fixed. And of course they were aware that beyond that fence was a live rail wire. Secondly, were they aware people might go near it? Yes, because they had heard reports that there had been trespassers onto the railway line. Finally, should they have protected against it? Well, it's not difficult, it's not expensive to fix a fence, and actually they have a statutory duty to do it anyway. So tick, 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 they owed the kid a duty of care even though he was a trespasser. Basically, you've brought it on yourself. Now, case examples where this failed, in Rind versus Astbury Water Park, there was a fiberglass container half buried at the bottom of a deep lake. How would the occupier be aware of that to protect against it? They weren't liable. In Higgs versus Foster, there was a coach park that was normally shut. A police officer entered without a warrant. The coach park would never expect people to go in there at night, so they weren't liable. And then finally, going back to Tomlinson versus Congleton Borough Council, yes, there had been people swimming in that lake before, but they had no swimming signs. They had wardens telling people off for swimming. They had signs up telling them about this horrible algae that was in the lake. And also as well, they were undergoing a kind of really expensive landscaping project to basically turn the place into a massive swamp so people wouldn't want to swim there anymore. What else do we expect the council to do? You can't fence off an entire lake. That's not a reasonable thing to expect the council to do, because at the end of the day, and the House of Lords was quite clear about this, people have free choice. We're intelligent adults and we should be making a choice that if the signs say no swimming, if the warden tells you off for swimming, don't swim. But if you have all three, then we have a normal negligence rule. The occupier owes a duty to take reasonable care to make sure you're not injured. So basically, they should take reasonable care to make sure this danger doesn't harm people. Remember, it's personal injury claims only. You can't claim for your damaged stuff. And just have a look out here. Has the occupier warned you of the danger? Now, this links to the defence of volenti non-fit injuria, that if you volunteer to the injury, you can't do anything about it. In other words, consent. The key with this is that any warning signs must be clear and sufficient. So they have to be big, bright, bold, in a suitable place, and they have to be worded super simply that really makes clear the danger. So if you have a sign that says, warning, tiger on the loose, if you decide to go through that door, that's your own problem. I've made the sign really clear, really obvious. You are aware of the danger, therefore you consent to any harm that happens. However, if I just have a sign that says, danger, danger from what? Small children, tigers on the loose, fire everywhere, knives falling from the ceiling. Who knows? How do I keep myself safe? How do I know whether to go through that door or not? Another little hint that students tend to get wrong. Staff only is not a warning sign. It's a prohibition notice. It's saying you can't go in. Staff only, what is it warning you of? Hopefully that's quite clear. I'm also going to go through the 1957 Act in a bit more detail. It's a bit more complicated, a few more things to go through. Thanks.